Good evening and a very warm welcome to everyone. Today, it is an absolute pleasure for all of us to have with us Mr. Sanjay Hegde, sir, Senior Advocate, Supreme Court of India, for this session on the topic Advocacy and Civil Rights. I would like to extend my warmest greetings and heartfelt welcome to sir on the behalf of the faculty, staff, and students of Campus Law Center. Sir graduated in law from KC College, Mumbai, and started his career as an advocate in 1989. In his more than 30 years of continuing journey at bar, Sir has appeared in several courts and forums representing individuals, organizations, and governments on matters ranging from corporate law, international law, human rights, to name a few. As a strong proponent of democratic values and a leading voice for human rights and civil liberties, Sir has represented cases involving issues of civil liberties and habeas corpus petitions. In 2016, Sir was appointed by the Honorable Supreme Court as Amicus Curiae in a Nirbhaya rape and murder case, and in 2020 as one of the mediators for the Shaheen Bagh Protests. Across the world and throughout history, some of our greatest achievements of justice and civil liberties and rights have been led by dauntless lawyers. As the world around us evolves at a fast pace and new challenges and threats to civil rights from different entities emerge, the need for advocacy and civil rights becomes an important and it becomes relevant. Law students of today are defenders of civil liberties tomorrow, and with the responsibility of keeping the stream of justice pure, unsullied, and flowing. We students believe that we will learn immensely from Sir's years of experience, observations, and reflections, and be inspired to be fearless voices for voiceless. I would again like to extend a very warm welcome to Sir and express my sincere gratitude for being with us here.
Yeah, Numeha, anybody else?
No, sir. Sir, please.
So over to you.
Yeah. Thanks a lot, DU LawFac, for having me. When I accepted Anumeha's invite, I had no idea that I'd be in the thick of a huge case and rather tired out. So before we start off, Anumeha, how much time do I have? And
Sir, we can have around 30 to 40 minutes, and we followed by interactions. Student want to ask questions.
About half an hour
Yes.
or so of speaking on advocacy and civil liberties. The first thing that I'd like to tell students of law is that advocacy and civil liberties are not contradictory to each other. Very often, civil rights do keep coming into question, and there is a certain feeling that it will be only defended by civil society, a certain kind of advocates who have taken a vow of poverty, chastity, and disobedience, or probably that there is a particular scruffy kind of advocate who does civil liberties matters. I hope that that is not the case. And in fact, one of the greatest disservices that you can do to civil liberties is if you advocate it in a manner which is not very civil. You don't need to be loud to have yourself heard. You need to be effective to have yourself heard. And the history of civil liberties always has been quiet men and women who have stood up and said, why is this so? Please tell me your authority. Please locate it in the law. And it has been also the course of history that many of them who have asked inconvenient questions have suffered. But it is also the course of history that many who have advocated have gone on to be great liberators of countries and ideas. If you look at the at Gandhiji's own life. He starts off as a barrister. He comes back from England as a barrister, has a rather not too successful career in Bombay, goes off to South Africa essentially to do what is today called corporate law. He had one rich client who set him up in practice in Durban. But there, when he came across the cause of Indians, where he started advocacy with that simple step of saying, look, I have a first-class ticket. I can't be asked to go back into the third class. And from there on, the journey went from South Africa, where he earned his spurs, back to India in 1920, almost in time as Tilak died. And then, through his very life itself, he was an example which went on to achieve independence. At the same point of time, there was another advocate, a leader of the Bombay Bar, one who was westernized, who spoke impeccable English, who was fond of his drink, and equally well enjoyed a bacon sandwich. Yet, he too stuck on to his cause, and where he thought that two brothers couldn't be in the same family, he then argued it like a partition suit. So our subcontinent itself gives you many, many, many examples of people who have been successful in law, who have been unsuccessful in law, but who have nevertheless gone on to stand up for causes and make a change. The father of the Constitution, for instance, was not very successful as a politician. He probably never could get elected on the strength of his own party. It was always, whenever he was elected to the Constituent Assembly from a seat in Bengal, in the undivided Bengal, which then later became part of Bangladesh. That seat was arranged for him by Jogendranath Mandal, who then became the law minister for Pakistan, on the strength of the Namashudras. Then it was the Congress who got him elected from Bombay into the Constituent Assembly, made him the chairman of the drafting committee. And this was part of the genius of that, of somebody who had not yet forgotten his law or his appreciation of men and women of law, Mahatma Gandhi. It was Mahatma Gandhi's suggestion that, particularly in the backdrop of partition, it was very, very necessary to keep the depressed classes on board by saying that there would be a constitution which would be guided by Dr. Ambedkar. The Constituent Assembly itself, if you look at it, had very many great men and women of law who advocated various causes. You had the president himself, Dr. Rajendra Prasad, who was also a lawyer from Patna, who had been noticed as a good junior by Sir Ashutosh Mukherjee. So there were several men and women of law who came together at a crucial moment in our history, when we had suffered a huge economic decline, we had suffered partition, we had seen what wrong ideas of constitutionalism and nationalism led countries to. We had seen in the Jewish Holocaust, we had seen the World War, we had seen partition violence, we had seen the murder of the Mahatma. It was in that context that we achieved almost a miracle. We got a magnificent constitution through in 1949, which came into effect in 1950. And it's a document, it's a constitutional compact handed over through the generations, and each generation sometimes renews its vows with that constitutional compact. One of the earliest people who propounded that theory that the constitution was nothing but a contract between the people of India and those whom the people chose to be rulers was quite strangely, or quite surprisingly, or quite unsurprisingly, depends on your point of view, the 𝐏𝐸𝐚𝐬𝐢𝐬𝐢, which had totally rejected Jinnah's idea of Pakistan. They said that the constitution which India had brought in was a constitutional compact, a muadda was the word that they used, that individual rights would be respected and that they thought that their personal law would not be touched. That compact saw us through the early 2 or 3 generations post-independence. You all are young post-millennials, I assume. I once asked a historian, why was it that, in the early years post-independence and right up till the emergency and till you could almost take 1992, the demolition of the mosque in Ayodhya, to be a defining moment. Why was it that there was relative peace in the earlier years? Why was this how did this constitutional compact go along? And he gave me a very interesting answer. He said that उस ज़माने में लड़ने के लिए पैसे कहाँ थे? People were more concerned with feeding their families, seeing to it that their little income stretched a lot. Post 1991 liberalization, India has been a different country. And one of the things that I think that India has got wrong is that while it has liberalized largely economically, it did not do any attempt at a liberalization of society. And there haven't been enough people who have worked on the social angle of things. We are now at a particularly dangerous moment where, again, societies are being labeled according to religious beliefs or according to caste divisions or according to various divisions. That is because, to some extent, the compact with India, the constitutional compact that every Indian citizen has with the Constitution, starts getting frayed when you start identifying some Indians as being more Indian and some as being anti-national. We, as men and women of law, as advocates of civil rights, have at this moment in history a profound duty to reaffirm to our constitutional vows, which say that there will be liberty, equality, fraternity, and the next phrase, not many people pay attention to, assuring the dignity of the individual. It is only in individual liberties that the greater public good, it is only the protection of individual liberties that the greater public good resides. We are all minorities of one. Each of us has majority and minority characteristics depending on where in India we are. I may be part of a religious majority in Delhi. But if you were to ask me linguistically, as a Kannada speaker or a Tulu speaker, I would be a linguistic minority in Delhi. So please do not assume and do not let people assume that civil rights are only a matter of minorities or that the majority is protected anyway. In the US, they have a particular saying that a Republican is a Democrat who got mugged. A Democrat is a Republican who got arrested. So it's like that. It is, while we need law and order in society, but we cannot have it enforced by lawless men who answer to no law, who answer to no constitution, who are drunk on power, who think that their power has no limits. We are in a constitutional compact which requires citizens to ensure that each of them defend each another's liberty. When I was young, we had something called the national motto or something, which said, India is my country, all Indians are my brothers and sisters. I don't know whether it is still printed on textbooks. These days, textbooks also become so, have so many changes. But that is part of my constitutional creed. Now, one thing I began by telling you that, advocacy, civil rights advocacy need not necessarily be scruffy, need not necessarily be at your cost in that sense. But I certainly think that you cannot do civil rights advocacy without being a good advocate yourself on other topics. What you do on the advocacy of civil rights will be your contribution as a lawyer to society. But unless you run a competent office which can draft contracts, which can go to court on writ petitions, on suits, which has a steady revenue stream, all out of which you derive both the strength as well as the credibility to carry on your civil rights advocacy. I am very grateful to the lady who introduced me, that she didn't use a word that many people sometimes use, activist lawyer. I take exception to that. I'm not an activist. I'm a professional inactivist. I don't jump into any and every cause that comes my way. I do try to choose my battles. And what I give off is I give off my effort, I give off my time. I do cases as cases, not as causes. But often cases come to court after they become causes in the houses, in the streets, or wherever. So if I were to encapsulate it in just one share of Iqbal, which says, खुदी को कर बुलंद इतना कि दर तकदीर से पहले खुदा बंदे से खुद पूछे बता तेरी रजा क्या है. Strengthen yourself first. खुदी को कर बुलंद इतना. That when you go to court, the judge does ask, yes, Mr. So-and-so, yes, Madam So-and-so, what is it that you want? I will pause here for a minute because, no, not for a minute, I'll pause here to take questions, because I also firmly believe that merely droning on and on does not particularly further the conversation. And you learn much more in conversation than you learn from merely listening to a lecture. Whoever is moderating the questions, please take over.
we request the students to shoot in their questions if they have any. Sir is very happy to take them. You can, sir, can they unmute and ask their questions?
I have no problem, but then too many people will unmute at the same point of time.
Yes, sir. I'll just
And
read them.
so how do you handle questions in class these days?
Alankrita, I think there are already questions in the chat box. You can read them and maybe sir can
Yes,
answer
ma'am.
accordingly.
Yes. So the first question is, will this, okay. Nowadays, corporate law is more attractive to budding lawyers and also pays them well. So why should one join the sometimes threatening and cumbersome civil rights litigation? And how budding lawyers how can budding lawyers be motivated and educated to join more and more number of areas and more more numbers in areas of this practice?
Well,
And the
listen,
student is Ajit Kumar Nandan.
Ajit, there is no one straight answer to this because it does depend a lot on people's circumstances. Many people have studied on student loans and things like that, and especially in the private law universities. So they do need corporate jobs which would pay off those loans and which would establish them. There are others who have the luxury of families to fall back on in the initial years. There are others yet who have great stores of resilience and fortitude, and they say we will nevertheless go on. But speaking for myself, I mean, I did in the early years try to work out with a few corporate firms and things like that, and I found it immensely boring to keep writing the same thing over and over again just so that the client could be billed billable hours and all that. So, and nothing beats the thrill, at least for a courtroom lawyer, of getting into the courtroom with adrenaline pumping, the judge against you, and engaging with the judge and hopefully turning him. One thing that I do after a matter is to switch off the intensity. This, I think it was Mr. Kapil Sibbal's father, the late Hiralal Sibbal, who lived well into his 90s, who said that you will be a good lawyer if you live long enough. If you intensely continue your courtroom battle in your head after the matter is over, you are unlikely to get away without effects on your health. Next question.
Thank you, sir.
Just one second. Sorry, reverting to Ajit. Why? How do you encourage more people to come into courtroom law? There are always enough people in courtroom law. I don't think you need to encourage more people to come into law. People have to find their own strengths. Some people have their strengths quietly sitting and working on a desk. There are others who find their strength in opening their mouth in courts. You find out what kind of person you are and what suits you, what you are happy at, and go that way. There is no clear answer in the abstract. Yes, the second question, please.
Thank you, sir.
So I think a little bit more of the same question by Ajay. It says that at the same time, it is also argued that law colleges are producing more four-year law graduates, lawyers and judges, but lacks that's 4 lakh per year. Okay, sorry. In this situation, how civil right litigations can be made more attractive and motivating areas of practice? Kindly enlighten us with reference to NRC agitations, 𝐏𝐥𝐚𝐜𝐞𝐦𝐞 or Pegasus issues.
Well, Bhima Koregaon, NRC and all that, these are all individual cases. You have 4 lakh law students coming out every year. Not everybody will find a career in law. And by that, I mean both corporate law as well as courtroom law. not everybody will become a transactions lawyer or a litigating lawyer. But a legal education is groundwork for straight thinking, logical thinking, and it helps, and incisive writing, and various other skills that you also acquire in law school help you everywhere in life. There have been people who have come out of law schools who have ended up running Indigo. There have been people who have gone to the best law schools and then found their vocation doing as chefs and whatnot. I have two children who have gone to law school, and I've told them that just because you've got a law degree doesn't mean that you necessarily have to be a lawyer. It is good training for the mind. It gives you very many life skills, and it also gives you a peer group who will stand with you through your life's journey. I would not necessarily take the numbers as threatening. Yes, from my day, when many of us who didn't want too many things to, didn't really know what we were going to do, but wanted 3 more years of university life, joined law faculty or law college, wherever, and we were taking time finding ourselves. Now you have people coming into law straight after the 12th, 5 years of law school. So they seem to feel impelled to necessarily seek a career only as lawyers. I don't see such a restriction. The world is before you. You have skills, and there are so many new fields about which they may not need lawyers, but they certainly need regulation. So you asked me what blockchain is, what crypto is, I have not a clue. There are so many emerging areas which will require legal skills. And using your legal framework also gets you ahead in thinking, and your ability to read a lot, compress it into concise written output is a great life skill. Next question, please.
Yes, so the next question is by Vibhor Sharma that says, there have been several questionable decisions involving civil rights infringement. How can a civil rights lawyer keep herself motivated in such a scenario?
There are several questionable decisions in all areas of law. Judges are human. They can get it wrong. They do get things right most of the time. But there may be sometimes reasons why a judge gave that, or there may be reasons why a judge misunderstood some submission in court or the facts of a situation. But how do you keep motivated? That's a general life lesson. Somebody said that success is going from failure to failure with no loss of enthusiasm. In the beginning, there will be many failures. But if for fear of failure, you fail to stretch your hand out and say, look, I'm going to do this, then you will never get anywhere. Put your hand out, get it burnt, get it seasoned. Keep doing the best that you can at whatever stage of learning that you are at. That's the only way. And lawyers often have an instinctive sense of the fighter or the warrior in them. Just say, these people will not get me. Even in your worst times, that you are still ready to get up, dust yourself, and march off. Next question.
So the next question is from 𝐏𝐥𝐚𝐜𝐿 Ghosh that says, how can we overcome the challenges caused due to the delay in listing of high priority matters and financial feasibility, which acts as a deterrent for a common man to pursue the court route of getting access to their liberties?
The system is the system as it is. And you can try your best, and without you will not have the same resources that a high flying corporate matter has, that is unlimited amounts of money. Minus money, you have the same resources as all other lawyers. You may have superior brains, you may have greater persistence. So you have to just you have to keep at it. Yes, first generation lawyers who have no other family support will find it much harder, but they are much more likely to go on much further than people who come from families that are well settled. It is not necessary that a family well settled in law will necessarily see that the next generation also is equally well settled. I know of many people who are sons of very great lawyers and very successful lawyers who in courtroom law have not had the success. And in many of your families, you sometimes see two siblings where one is in a top post. People do not even know that the other even exists. So do not be put off by the fact that you are first generation. How do you work your finances through the early years? Varies from person to person, depends on circumstances. I sort of grew in the profession only after I became the Senior Counsel for Karnataka in 2000. I had become a lawyer in 1989, so that's a period of about 11 years. And in the first 6 months after I took over the state of Karnataka, I was married then. My 2 children had been born. My wife was working in a corporate job, but my own bank balance had gone to some 3,000 rupees at that point of time. And these phases can come in at any point of time. It is said about the great Sir Tegh Bahadur Sapru, that he had some that in the old days in Allahabad, that 1 year, that in 1 month, his monthly fee book showed some 80,000 rupees. And the next month's fee bill showed just some 800 rupees. Variations are huge, especially in courtroom law. Sometimes you are the flavor of the season, sometimes you are out of favor. So financial planning, if you want financial security, then financial security on a even that you will go from 1 to 2 and 3, 4 and above, grade 1, grade 2, grade 3, grade 4. Then courtroom law is not. Courtroom law is sometimes you go from 1 to 10, 10 to 100, and sometimes you don't even get 1. Next question.
So next question is by Mohit Gandhi. He asks, sir, what are the courts? Just a minute. So are the courts becoming increasingly reluctant in proactively protecting the fundamental rights? I refer to temporary suspension of fundamental rights by court orders and also pending habeas corpus petitions.
Are courts being increasingly reluctant? Well, the answer to that is a quotation from Mr. Nariman in a conversation with me, but let me give you some background. Mr. Nariman was Additional Solicitor General for India and the only additional ASG at that particular point of time when Mr. declared the emergency. Okay. So Mr. Nariman was defending some detentions, some people who had been detained before the emergency, and the Chief Justice of the day would have nothing of it. The liberty of the citizen is paramount and all that. Mr. Nariman resigned during the emergency, and then during the emergency he came on behalf of some people who had been detained, who needed temporary bail so that they could vote at an election of some mayor or something. And the same Chief Justice said that, look, no, there is no urgency. After all, there is a detention and there is a detention board, you go there. So much later, just pre-2014, when I was talking to him about courts and all that, he told me that we would see a conformist court if there was a majority government. Because you see, the great advances in law, public interest litigation, the Jain Hawala, and various other cases where the judiciary came on strong was often in cases where there were coalition governments, where there were no governments which were reflected by popular will. So I think I have sufficiently indicated the answer to your question.
So should I go on with the next question?
Yeah, next question.
So the next question is by Manmohan Sharma, and he is asking, sir, what is the thing that takes small cause matters 7-8 years in deciding?
Whether it is the small cause or any other cause, all take time. And they simply take time because we have this entire system where almost everything has to happen in court. And if you bring a wrong case to court, whether a citizen or a government, there is no real sanction against bringing bad cases to court. We are so obsessed with the process that we do not concentrate on outcomes. Now, I don't see, for instance, why many criminal cases can't be plea bargained at the prosecutor stage. Intrusion into the court's time is a very valuable resource. It's a non-renewable resource. Not every matter should require the attention of a judge. But yes, you must have a legal process, and that legal process must sort most things out. Why should depositions and cross-examinations be held on court time? You go to in the previously when you used to go to a district court, the judge would be hearing arguments in one case. There would be recording of evidence in another case going on simultaneously with the reader. And sometimes the judge would be writing the judgment in a third case. With this kind of divided attention, what can be done? And we have one of the lowest judge to population ratios in the world. Most developed countries have about 100 judges per million population. We are not even at 15. At one point of time, we were near 10. And we are a country which is increasingly getting literate and increasingly litigious. And we have so many laws. Previously, when marriages fell apart, people would manage to get a divorce or would work out a divorce. Now, one marriage often ends up in 10 different proceedings in various courts, both civil, criminal, plus the court of the RWA and the local Mamaji. So we need to really focus on outcomes. We need, as people, to work things out, and only where there is the judge's attention absolutely required, that is where matters should go. And if you go to a judge wrongly and take his attention, the judge must be able to sanction out. Supposing it's a first offense, the maximum punishment is something like 3 years. If the fellow is willing to undergo 15 days imprisonment and a fine, or to be released on probation for good behavior, why should it not be? Why should it require an entire trial with recording of evidence and everything before you go? Before a decision is finally arrived at some 10 years later and 15 judges later. There have to be great changes, both within the system and with us as people and in our approaches to litigation.
So the next question has been asked by Nilansha Gupta.
Yes.
The question she asks is it noticed that organizational decisions to represent the civil rights of the poor is sometimes based on ideological commitment? How do we go about combating the same and make sure that they are represented in an ideal manner?
Okay. One thing I firmly believe as a lawyer is that words of learned length and thundering sound, which amaze the gazing rustics ranged round, have no place in legal thinking. Use short sentences. Think straight. The question, if I've understood it rightly, is what do you do when the judge has an agenda? Or the judge has a particular way of thinking? Yes, judges are human. They have their biases, they have their agendas. There are certain judges who are pro-landlord, there are certain judges who are pro-tenant. There are certain judges whose daughters have had bad marriages who will think one way. There are certain judges whose sons have had bad marriages who will think that way. So your job is to do the best thing for your client at that particular stage. Tell the best possible story that you can tell for your client without lying. No lies, but put the best possible gloss on your case, and then you leave it to the judge. Of course, the first thing is that you, if that judge is likely to change or something, then you follow the great dictum that the person who wins in court is not the person who fights and dies the same day. It's the person who runs away and lives to fight another day. That's a doctrine from war, but it's equally applicable to the courtroom. But if you cannot, then put in your damnedest so that it is difficult for a judge to bypass essential questions that have arisen in the matter. Then there is always an appeal. I hope I've given you a satisfactory answer. What's the next question?
So the next question is by Abhimanyu Singh. He asks, is it advisable to straightaway start with an independent civil right litigation practice after passing law school? Or should one first work under a senior lawyer and then learn the craft and then start his or her own business?
I firmly believe that you do need to learn the craft of law, and you do need a practitioner to mentor you, to help you around. And most importantly, when you work under someone, you can make all your mistakes at his expense. In his cases, and then he can come and he or she can come and sort things out later. Whereas, if you go out on your own and make your mistakes and learn at your own expense, very often when you're finally finished learning, there may not be enough people who will then come back to you a second time. Next question, please.
So the next question is again by Ajit Kumar Nandan. He is asking, sir, do you think it is the right time, or are we too late, to make apprenticeship-based law education in India and also mandatory paid internship opportunity for all budding lawyers?
I mean, see, the moment you make all that, then there will be very few lawyers who will take on people. As simple as that. You gave that figure of 4 lakhs. So now, can you necessarily require any practicing courtroom lawyer that you will compulsorily take 2 interns a month, so 24 interns a year and pay them? Then it may not always work in all cases. Internships are necessary. I don't know about apprenticeships because the apprentice thing is like articles in a CA firm. Well, the CAs in the old days used to have a lot of checking and auditing to do. That's where articles, clerks were used. I'm not very convinced that there should be any formalization of articleships. Right now, the law colleges themselves, as they have this thing of internships, I think that system is better. In fact, there is also an argument against internships. In my days in practice, in law college, there was no requirement of internships. And my father was a lawyer. I used to follow him at times in court. And then some of his friends told him, why are you bringing him? It's too early. He will run away. So, yes. And there is also a thing that there are good internships and bad internships, as all of you all know. It's a very personality-driven profession. Some people teach, some people's offices teach, some people exploit, some people. It's an experience best forgotten, and the thing that it is over in 1 month is the best thing that can be said about it. So I'm against compulsion. That's where I come from. Next question, please.
So the next question is by Jayant Kumar. Sir, could you please give us some suggestions? How can we excel in the field of civil rights practice?
I think I've already answered that question. If you are a good lawyer in other areas of the law, then you will be a good lawyer in civil rights practice as well. I don't think India is yet at a stage where you can sustain yourself solely as a civil rights practitioner. So, yes, it's also a power game. India does not particularly have a system where non-governmental organizations currently are looked on with any kind of favor. Sometimes having an organized structure means that 10 governmental agencies can come after you if they don't like your civil rights work. So it is better that you are money comes from independent sources, and civil rights practice is an adjunct. That's what I feel at this stage. Next question, please.
So the next question. By Shaheen
Yeah. Your voice is cracking.
Alankrita, your voice is cracking. Maybe I'll.
Please take up.
Yeah, no, it's
Nilansha, can you please read the question? All right. Ma'am, the question, sir, the question is by Shah Khan. He is asking, why do few cases in court get more time and get listed frequently with more time for rights, while cases get listed after months? Is it a discretion bench? Or if it is at the discretion, should it be regular? Any get for the same?
Well, there are certain cases which brook no delay. The making and unmaking of governments, and say, or there is somebody facing a death sentence, imminent execution after a death sentence. So then courts are petitioned, and every aspect has to be looked at. Of course, it does great hardship on a landlord who is waiting continually for a case to be finally disposed of before he gets his or her property back. Or it can work great distress on somebody who in a service law matter where he or she was unfairly thrown out of office or denied a promotion. Yes, but then the discretion is not so much of the judges, it's often of the system. And yes, once a judge gets his teeth into a matter, it takes time. Next question, please. How many questions are there? They keep coming, don't they? We should have
two more questions, and then.
Okay.
Yes, so just two more questions in the chat box. So I think I'll just club two questions because they're very similar.
Yeah.
By Devilal Chaudhary that says it is about good internships, enlightened internships, and Sushil Kumar, whether it is advisable to start law practice in age 30s, especially in Supreme Court.
There is no age bar, and well, anybody can start practice at any particular point of time. I know of women who have come into the profession late, after childbirth and after the children have grown up and started going to school. There have been people who have joined the practice and then gone away in between, said no, gone away, done something else, come back up, and still had successful practices. The age is a factor, but it is not a determining factor. And as far as the Supreme Court is concerned, the one thing that I tell anyone, irrespective of age, who's planning to come to the Supreme Court to practice, is this: that the Supreme Court works about 185 days in a year. Your kitchen goes on 365 days. If you can solve that equation anyway, personal money, spouse's money, or whatever, or other income through business, and then only you can come. And the Supreme Court, at least in the old days, without virtual conferences, it was very easy not to be noticed for the first couple of years. Till people saw you in matters, in context, okay, this fellow does this kind of thing. You really didn't establish yourself. And the Supreme Court is also a very temporary court in the sense that the judges there change very, very frequently. People have tenures between 3 and 6 years. And when they change so frequently, each year is a new Supreme Court. So, so that means that any set of lawyers can come in at any point of time, and at any point of time they can find themselves totally out of the game. Next question.
So we have a few more questions. If you want, we can also take them towards the end.
I mean, sorry.
Or if you want, I can.
I mean, I
If
can
you-
take. I have another 5 minutes, because after that there is another thing coming up. So tell me.
So Alankrita, I think you can take 1 or 2 more questions and then maybe we can conclude. Okay.
Yes, ma'am, definitely. Sir, there is a question by Neha Naram, and she asks, sir, do you feel airspace would grow big future in
Sorry, your
India?
voice is cracking.
Do you?
Alankrita, maybe I'll repeat the question.
Yes, ma'am.
There is a question by Neha Naran. Do you feel airspace laws would grow into a big sector in future in India? Which areas of law do you feel will be areas to look out for in the future?
I don't know much about airspace law. It's a very specialized field. Yes, aviation as a sector will grow. There will be more and more resorting to technology law, especially blockchain verification and things like that. So yes, but if you look at law, there is a similar structure to most laws. There will be the definitions clause. There will be chapters on what organizations can do and what cannot do, what constitutes an organization. Once you get into legal practice, you notice that there is a pattern to acts and all that, and that somebody who is good at one field of law can often seamlessly change. You may think that you are going to be a lawyer in this field or that field. Very often, it's cases that find you, and then you become a lawyer for a different field altogether than what you set out to be. Don't close your mind to opportunities. Next question.
Sir, Alankrita?
Yes, ma'am. Ma'am, am I audible now?
Yes, you're audible. I think we can conclude now because I think sir has already given us a lot
Sir.
of his time. Because
Yeah.
the questions are never ending. Obviously, we would like to interact with him more.
Unfortunately, I have also given time to somebody else, and
Yes, sir, we completely understand. Because it was a very interesting session. Alankrita, you can continue.
Yeah, I think you can conclude now.
Yes, ma'am. Sir, and sincere apologies to everyone. I'll just keep my video off so that my voice does not break. Sir, on the behalf of campus, on the Business Assistance Campus Law Center, and then the college as well in the entire field, I would sincerely like to extend my utmost gratitude to you for joining us here, sir. And I would also take this opportunity to acknowledge support and guidance provided by our patron and professor in charge, Professor Dr. Alka Chawla ma'am. And I would also like to thank Ms. Anumeha Mishra ma'am, Assistant Professor, Campus Law Center, and Dr. Ritu Chakravarti ma'am, Assistant Professor, Campus Law Center, for coordinating the session and making it possible to have sir, and it possible for our students to hear sir out in person. It's actually a great honor. Thank you so much for joining us, and thank you for the session.
Thank you, everybody. It was a pleasure being here.
Thank you, sir.
Even if it was virtually. We hope that the pandemic has receded forever, and that life gets back to normal. All the best to all of you. Thank you very much.
Thank you, sir.
Thank you, sir.
Thank you very much, sir. Thank you.
Thank you, sir.
Thank you, guys. Bye.